The first African slaves to be introduced to North America arrived at Jamestown, Virginia in 1619. Approximately 20 Angolans, who were kidnapped by the Portuguese, arrived in the British colony of Virginia and were then bought by English colonists. The arrival at Point Comfort marked a new chapter in the history of the transatlantic slave trade, which began in the early 1500s and continued into the mid-1800s. The trade uprooted roughly 12 million Africans, depositing approximately 5 million in Brazil and approximately 3 million in the Caribbean. The number of Africans brought to mainland North America was approximately 400,000. The first record of a female African slave in Jamestown was made in 1625. She was referred to as Angela, a Negro woman. Angela worked in the household of Captain William Pierce along with 3 white indentured servants. Angela arrived in Jamestown shortly after the original group of African slaves in 1619. Early on, the slaves who arrived at Point Comfort were sold as indentured servants. Indentured servants agreed, or in many cases were forced, to work with no pay for a set amount of time, often to pay off a debt, and could legally expect to become free at the end of the contract. Many Europeans who arrived in the Americas came as indentured servants. Some of the Africans who arrived at Point Comfort in 1619 as indentured servants were forced into slavery and never freed. In 1640, a Virginia court sentenced rebellious servant John Punch to a lifetime of slavery. With fewer white indentured servants arriving from England, a racial caste system developed and African servants were increasingly held for life. Over several decades, Virginia enacted slave laws. The laws created what is called chattel slavery. Chattel slavery was the most common form of slavery in America. Chattel slavery classified people of African descent as legal property that slave owners could buy, sell, or own forever. Enslavers had complete control over the bodies and lives of those they enslaved, as well as their children. Most enslaved people were trapped in bondage until they died. In other words, slaves and their offspring were slaves for life and had no more rights than an ordinary farm animal. In 1662, Virginia enacted the enactment of hereditary slavery law, which made any child who was born of an enslaved mother a slave for life. Southern states adopted the principle of partus sequitur ventrum, which states that any child born takes the status of the mother. A child born to an enslaved woman was the property of the slave owner. Even if the slave owner was the father of the enslaved child, he was not financially responsible for either the enslaved mother or the enslaved child. The slave owner could keep the enslaved child or sell the enslaved child to a slave trader. Partus sequitur ventrum created a financial incentive for slave owners to impregnate their female slaves. And in the 1830s, partus sequitur ventrum facilitated the fancy girl trade. Fancy girls or young light-skinned female slaves were the daughters of enslaved women. As slaves, fancy girls were the property of whomever owned them. And whomever owned these fancy girls could do with them as they pleased. Slaves owners, who could possibly be their fathers, sold them to slave traders. As temporary owners, slave traders typically raped these young women before selling them to wealthy men at slave auctions for the explicit purpose of sexual exploitation. Raping a fancy girl was not recognized as a crime in the South. Fancy girls could be raped by their new owners. If these fancy girls gave birth to children, their new owners would not be financially responsible for either them or their enslaved children. On plantations and farms in the South, slave owners were known to force their female slaves to have sex in order to produce as many children as possible. By age 13, female slaves were expected to have their first child. By age 20, female slaves were expected to have 4 or 5 children. By having children, female slaves increased their owner's wealth. Thomas Jefferson believed that his female slaves were more valuable than his male slaves. Female slaves had children, which added to Jefferson's capital. In 1820, Jefferson said, "I consider a woman who brings a child every 2 years as more profitable than the best man of the farm. What she produces is an addition to the capital, while his labors disappear in mere consumption." Interracial sexual intercourse between enslaved women and white men produced offspring having a wide variety of racial characteristics, such as skin tone and facial features. This racial spectrum was categorized by the terms Negro, Mulatto, Quadroon, and Octoroons. In some southern states, a slave was legally anyone with even a drop of black blood. Some Quadroons who were 3/4 white and Octoroons who were 7/8 white could pass for white. In the South, there were slaves who were indistinguishable from white people. Fancy girls were already sold in New Orleans for 4 to 5 times as much as a female field laborer. Some fancy girls sold for as much as a prime male field laborer. But fancy girls who appeared to be white and behaved as though they were white could be sold at a premium. Wealthy men considered these enslaved women status symbols. When African slaves were being imported into the United States, it was easy to distinguish between white people and black slaves based on visible racial characteristics, such as skin tone and facial features. After 1808, when the importation of African slaves was banned, an ever-increasing number of slaves were born in the United States. And an ever-increasing number of those slaves were mixed race. Eventually, an ever-increasing number of slaves were indistinguishable from white people. Mulattoes, who were 1/2 white, begot Quadroons, who were 3/4 white. Quadroons begot Octoroons, who were 7/8 white. The most sought-after fancy girls tended to be Quadroons and Octoroons. The one-drop rule stated that any person with even a drop of black blood was black. Indiana, Maryland, Missouri, Nebraska, North Carolina, North Dakota, and South Carolina all relied on a 1/8 rule. A person was legally white if they had less than 1/8 black blood. On the other hand, Alabama, Arkansas, Georgia, Kentucky, Louisiana, Mississippi, Oklahoma, Tennessee, and Texas defined anyone with any blood of the African race in their veins as black. A racially mixed person, with black ancestry, was assigned to the subordinate group, which was the black race. For example, the child of a white father and black mother was black. The child of a black father and white mother was black. A child with at least one black ancestor, such as a grandfather or great-grandfather, was black. The term for this is hypodescent. In 1665, the Virginia case of in re mulatto made hypodescent the legal standard in Virginia and eventually the rest of the nation. The one-drop rule only applied to persons with an ancestor of African descent. In 1705, Virginia defined a Negro as the child, the grandchild, or great-grandchild of a Negro or anyone who was at least 1/8 Negro. The one-drop rule did not apply to persons with an ancestor of Native American, Hispanic, or Asian descent. The one-drop rule was applied only in the United States. No other country adopted the one-drop rule. In the United States, the one-drop rule is taken for granted. In the United States, the one-drop rule has been accepted by both whites and blacks. Federal courts have taken judicial notice of the one-drop rule as common knowledge. Most state courts have upheld the one-drop rule.